The biggest single change is the unification of the cooling off period. So with effect from the 13th of June, anybody who is buying online or who is buying within their own home will have a 14-day cooling off period. Essentially, if you are a bricks and mortar retailer, if you're selling non-day-to-day items, you need to give certain information in writing to the consumer. The regulations aren't very helpful in that they tell you what a day-to-day item is, and the examples that they give are very straightforward. So they say that a cup of coffee or a newspaper is a day-to-day item. I think that a non-day-to-day item will be something like a sofa or a motor vehicle or a washing machine, something like that, the sort of thing that you buy once in a while. Well, car dealers will be affected. So when you go and buy a car, and I recently bought a car, and they gave me a piece of paper when I bought the car, which I don't think they'd changed since about 1982. And they're now going to have to give you 9 bits of information. And if they don't give you that information, that's technically a breach of contract. And I guess that if it's a serious breach of contract, you, if you're a consumer, you could argue that because it's a serious breach of contract, you're not actually bound by the contract to buy at all. Doorstep selling is a sort of technical term I think that we lawyers use, but I think that most doorstep sellers or people who are caught under the definition of doorstep sellers wouldn't like to be called doorstep sellers. It catches people like electricians, plumbers, people selling fitted kitchens, basically anybody who comes to your home and you sit down in your home and you sign a contract in the home. Essentially, where you do that, you will have a 14-day cooling off period. If they don't give you the right information, that cooling off period is essentially extended to 12 months. And it's really important for the retailer to get it right, because not only do they run the risk of the cancellation period being extended to 12 months, but also it's actually a criminal offence for them not to give the correct information. Helplines are changing. Certainly, where you've got a helpline which is used in respect to the goods or the services that you have bought, you can't charge a premium rate anymore. So, for example, a colleague of mine recently bought a fitted kitchen, wanted to something happened to the hinges, phoned up the helpline to say something happened to my hinges. Can I have some new hinges because it's within the 12-month guarantee period? And they had entered a very friendly conversation with the person on the other end, and indeed the kitchen supplier returned and sent some new hinges. And it's only when they got the telephone bill did they realise it's a premium rate number. That sort of practice won't be possible from the 13th of June. Well, it is complicated. I mean, if you look at the new regulations, they run to about 40 pages of small print. So I hate to say, but people really do need to take legal advice on this, because if they get it wrong, the consequences are quite serious. Customers will have enhanced cancellation rights, and particularly in respect of doorstep selling, you could be committing a criminal offence.